Hello, you have Ted Corless with the Corless Law Group. Today's media production relates to issues associated with the inspection and maintenance of large condominium buildings here in the state of Florida. That process, oftentimes directed by the age of the process, is commonly referred to as a milestone inspection. Over this past year, the legislature in the state of Florida considered various requirements that once particular condominium developments reached a particular age, a particular structural evaluation would be required. We have the benefit now of sitting down with Byron Anderson of SEI to learn more about milestone inspections. Hello, you've got Ted Corless with the Corless Law Group, with our continued series associated with condominium developments in the context of last year's tragic event in Surfside community in North Miami Beach, which ended the lives of 98 people and affected hundreds more. The question becomes, you are on a condo board, or you own a condo. What should be done in the future to avoid similar issues like those that occurred at the Surfside community? Should you be inspecting your buildings? Well, one of the efforts that was taken this past year was Senate Bill 1702. Now, what that bill was designed to do was to mandate that buildings receive what is being referred to commonly now as a milestone inspection. That means that the buildings should be inspected, had the bill passed, based upon its age and its location to the water. But now that those bills did not pass, it passed in the House, passed in the Senate, but the two houses couldn't come to an agreement on a final bill, so it died in committee. Now, if that's in fact the result, what responsibilities do you have now, even though they're not mandated by the state of Florida? We're going to continue to provide this information so that unit owners and condo boards can have a better understanding as to what some best practices might be in the future. To assist in an evaluation of that particular issue, we bring you today Byron Anderson. Byron Anderson is a professional engineer, and we'll let him talk a little bit more about his company and his background. Hello, Byron.
Hey, Ted. Good afternoon. As you said, I'm Byron Anderson. My company is Structural Engineering and Inspections Incorporated. In addition to being a professional engineer, I'm also what's called a special inspector in Florida, and that is relevant in this case or in this matter because back in the 80s there were several building collapses, most notably one in Cocoa Beach. And following the collapse of that building, Florida legislation passed what we commonly call threshold inspection laws or special inspection requirements. And as part of that, any building that is greater than 3 stories, 50 feet, or has an assembly occupancy of 500 people or more is required to be inspected by a special inspector, which is a design professional with a special qualification in the state of Florida, in addition to the authority having jurisdiction during construction. So going back to what we were talking about a while ago, milestone inspections, as you said, and you and I have done a separate podcast on the collapse at Surfside, the milestone inspections really are coming out of the aftermath of that tragic event that occurred. And I'm just going to take a moment here to talk specifically about what the legislation had in mind with milestone inspections, what the requirements were, although it wasn't passed in this session. We're sitting here in late March and session just closed. I know there's talk of potentially having a special session to address that and some other items, or there's a high potential that it could get resolved in the next session. But what was happening is that the milestone inspections would be required mandatory building inspections. They would require the owners of multifamily residential buildings that were 3 stories or greater to have those milestone inspections. The condominium and or co-op boards would have to arrange for the inspections, and it would require the engineers or architects performing the inspections to submit the results of their inspections to certain entities, i.e. the authority having jurisdiction. So as we said, it was for multifamily residential buildings, so this does not apply to commercial office type buildings. that are greater than 3 stories in height, and it makes a geographical distinction between whether you are on the hurricane coastline or you are greater than 3 miles from the hurricane coastline. If you are greater than 3 miles, then the inspections would have to occur within 30 years after the issuance of the certificate of occupancy, and then 10 years thereafter. If you're within that 3-mile zone, the time frame was reduced to 20 years after certificate of occupancy and 7 years thereafter.
Now, let me ask you something about those particular time frames. A lot of times the conditions that are set forth in legislation are born out of legislators that don't necessarily have the most accurate understanding as to the way these things come together. And sometimes they're being influenced by different people who have financial interests in this particular field, meaning that there might be developers out there that do or don't want these kinds of milestone inspections. What is your reaction to those different elements? The fact that 20 versus 30 or the 3 miles versus closer.
Well, I think that there are instances on either side of that equation that could be either problematic or not problematic. What I mean by that is that I know for a fact that there's buildings that we've been involved in that if you waited till 20 years, the building would have no longer existed. It would have been a pile of rubble.
Wow.
On the other side, there's also buildings that were 100 years old that we've inspected that perfectly fine. I think the idea is that 20, 30-year guideline is a general guideline for you to be able to identify catastrophic failure type problems. Likely, any building is going to have maintenance occur prior to that, and many buildings may have some sort of either construction defect or some sort of other deficiency associated with the building that's going to necessitate repairs take place prior to those timelines. I mean, our feeling is the best practice would be to have your building inspected as soon as you take control of the building by an independent professional, not a professional hired by the developer, and then maintain a relationship with that professional throughout the life of the building and have them come back and do repeat inspections on a regular basis to try to catch problems and resolve the issues associated with the building before they become major catastrophic problems. Very much like, a person going to a doctor on a regular basis and getting regular checkups.
And if you were getting a chest x-ray, for example, if you got one every year, the doctor that you're getting those sent to for a read would have the ability to see your history over time and be able to discern subtle changes that may have been occurring. And I guess these buildings are going through that same enterprise. That over time, those particular conditions are starting to occur and express themselves. But there's also this concern, I guess, that sometimes what people do is they may see a crack in a building and they figure if it took 25 years for the crack to get there, then maybe it'll take 25 more for the real problem to present itself. But that's not the case, is it? Because buildings can accelerate once the water starts getting in and other problems start presenting themselves.
Not only can they accelerate, but oftentimes the crack that you're observing is just a canary in the coal mine. That it may be an indication of a larger problem that you really need to have investigated.
Sure.
Going back to the milestone inspections, they must be done by a licensed engineer or an architect that's licensed in Florida and has experience in inspecting buildings and in particular the structural aspects of buildings.
Now, are there engineers, when you talk about engineers, the state of Florida licenses professional engineers, and you're obviously one of those. Is there a sense that these kinds of milestone inspections should be done with a professional engineer with a particular specialty behind them?
Yes, absolutely.
And what would that be?
I would say structural engineering.
Juxtaposed to, what about a geotechnical engineer?
A geotechnical engineering really isn't going to have the education, training, and experience to identify structural problems with the building, i.e. concrete failure, wood frame failure, things of that nature.
They're going to want to get a shovel and go out and dig and find something underground when the structural experts are going to be looking at the expressions in the building in terms of movement or cracking or... Correct.
Yeah. One of the things that I say often is that I have a vast background in design and inspecting buildings as they are being constructed. I don't know how I could do my job from a forensic engineering perspective without having that background of knowing how buildings are constructed and put together. And so, I really think it takes a structural engineer that has a background in design and understanding how buildings come together in order for them to accurately diagnose conditions that are happening at a property.
Totally get that.
All right. So the legislation basically breaks milestone inspections up into two phases. A phase one inspection is able to be done by any engineer or architect in the state of Florida. And they're essentially doing a visual examination of all building areas, and they're providing a qualitative assessment of the structural conditions of the building. What they're looking for are things like cracks, distortion, sagging, excessive deflections, significant misalignment, signs of leakage, peeling finishes, things of that nature. So what they're looking for is visual clues, if you will, of problems with the building. Is water leaking into the building? If so, where is it coming from? Are there cracks or bulges or anything that's occurring? If so, what's happening to those? If none of those conditions are observed at the building, then the phase one inspection is all that's necessary. So the architect or the engineer writes a report saying that we've completed our phase one inspection. This is what we've done. This is what we've found. This is the current condition of the building, and that's submitted to the authority having jurisdiction and to the building owner. If, on the other hand, any of those aforementioned conditions are discovered, then a phase two investigation is required.
Now, if I'm a unit owner, I think the legislation as it was written would have required that there was a filing of some certificate of satisfaction that you've completed a phase one and that there was no issues available. And that way, someone who's coming into that community and is considering buying a home there, they could actually gain access to that inspection and get a sense of how things are appearing. Is that kind of what the idea is?
Yes, sir.
Okay,
Absolutely.
Got it.
Okay, so if a phase two inspection is required, the phase two inspection can only be done by a special inspector, which again would be a professional engineer with the special qualification as a threshold inspector or special inspector, such as myself, under state Florida Board of Professional Engineer guidelines. And the phase two inspection is going to be more in depth. We're going to go out and start to look for signs of significant distress. We're going to potentially do intrusive investigations at the property.
You're talking about destructive. You might have to core a wall, for example.
I prefer the term intrusive versus destructive,
Okay.
But you get the idea.
Yeah, I guess if your doctor says, I want to do a destructive removal of something on you, you're like, huh?
Yes, exactly.
Yeah, no, I understand.
So yes, cutting into the building envelope, cutting into drywall on the interior of the building, removing sections of concrete, whatever may be necessary so that we could positively identify the conditions of the building and then prescribe effective repairs. The special inspector must have at least 3 years of experience in inspecting threshold buildings, so they have to have additional experience in addition to that, and they must have 2 years of experience in the design of threshold buildings.
And again, these particular conditions that you're describing, this is what that was ultimately passed by both the Senate and the House, but it ended up not making it out of a conference committee, and it didn't really have anything to do with the nature of the inspections. My understanding is the reason the bill wasn't passed is because of more condo-related issues associated with how condos pay for capital improvements. The House wanted to require that every time they have an annual meeting, condos would be required to fund long-term capital projects every year. They can't just wait until they need a new roof. They have to kind of do a calculation and start saving along the way. But the Senate bill didn't want to require reserves, and so the bill just died for that reason.
Yeah, my understanding is that both bills were lockstep in the requirements for the inspections and who could be doing them and the timelines associated with them.
Got it.
So if during the phase two inspection it's discovered that the repairs are necessary to the building, then the repairs must be prescribed and completed prior to the signing off of the phase two inspection. Then the association must keep a record of these inspections, a running record of these inspections throughout their existence. So that's kind of the breakdown of what a milestone inspection was. As we said earlier, it's something that may become necessary or required by law, but we think it's absolutely necessary, just as the right thing to do as an association or a condo owner, to make sure that you're protecting your investment and, more importantly, protecting the life, safety, health, and welfare of the public that's living in your building.
Now, in this situation, the fact that the state of Florida has not mandated these milestone inspections, would you agree it is a best practice to complete these, at least to some degree, to assess the status of a building that might be 30, 40, 50 years old?
Well, I think it would be prudent to do it as soon as you can take control of the building or take control of the process, to make sure that the information that has been provided to you up to that point is accurate. So again, we're using the analogy of the condo as a patient and the design professional as a physician. Well, you want to go get annual checkups and make sure that everything is working correctly prior to waiting till you have a problem and then you have to go to the emergency room.
Got it. Because ultimately, if you do it now, whatever it costs is going to be less than if you wait until the problem presents itself in a lot of other destructive ways.
I would say cost, not only from a monetary perspective, but also from a disruption of use perspective.
Or human life.
Human life perspective.
Right,
I mean,
sure.
It's cost across the board, not just monetary.
I understand. Well, I believe that now, as a property insurance lawyer, the issue of the condition of the property is always the first place that insurance companies will look, because they'll try and associate damage to a particular building with long-term maintenance, deferred long-term maintenance, as opposed to Hurricane Irma. And you find situations where the insurance company is able to identify what it describes as defective construction. Improperly installed windows would be a good example of that. At the same time, they might see that the property hasn't been painted regularly. And people forget, we live in a very intense environment with water and heat and wind, and it affects the long-term condition of these properties. And it almost seems to me it affects these multi-unit properties more so than it might affect a single-family residence. Do you think that's accurate?
Well, I think it's accurate because one of the factors that you did not put in there is salt.
Right.
And a lot of these multifamily buildings are constructed on beachfront ocean lines.
Getting washed with all of that sea spray. And I guess the other piece of it would be that you're higher up.
That's true, too.
Okay. So if it's a 25-story building, the units that are on the top are going to get a different wind exposure that, again, is going to, over time, cause deterioration. And ultimately, isn't that really what happened in Surfside?
In Surfside, based on everything that I have studied and come to believe to date, is that the problem started with design. It was not corrected during construction. There was a design deficiency. It was not corrected during construction. And then the problem exacerbated itself throughout time, in particular having these paver decks on the pool deck area in which you were getting salt water and salt spray that was getting on these paver decks. So you had reinforced concrete with pavers over top of them. The salt water was getting into below the pavers and setting on the concrete deck. The water was evaporating, leaving the salt behind, causing a degradation to the concrete. In addition to that, we saw large areas around the pool, and in particular the pool equipment area, which had significant degradation to the reinforcement. Well, the pool equipment area, you have other chemicals, acids, chlorines, things of that nature, and you also have stray electrical currents potentially from the pool equipment, which can aggravate the corrosion that's occurring. So those conditions, combined with a lack of routine maintenance, correct and proper maintenance, and then the problems were discovered before the collapse. And I think that there was a misunderstanding as to really the severity of the problems and the need for shoring to be applied in some of these areas prior to the collapse occurring.
If we had performed a phase one, as had been described in the bills that made their way through the Florida legislature, would it's the Champlin East building, is that the name? Yeah. Would it have passed a phase one inspection, or would it have necessitated going to a phase two special inspection as you described it?
It should absolutely have required a phase two inspection.
And the idea behind these bills is to obligate the inspections be done. But then there's the question about whether or not the individual communities are going to make the right choices in terms of let's deal with the problem that we have.
Correct.
Because the problem that presented itself there in the Surfside community, it was a combination that they had discovered these things late in life of the building, but then how quickly they responded to those issues is now, I guess, being in question.
How quickly they responded to them and how quickly they could finance the response to them.
Right. Right. I guess because we can pass these laws and obligate the inspections, we can require that they conduct certain work on a building. But ultimately, we're talking about a very large number of people that live in these communities.
Absolutely.
And sometimes you have board members that might be a little more interested in their own financial situation than necessarily assessing themselves if they happen to own one or more units in a particular property. Let's get to this issue of, again, I think I asked you earlier, even though the state of Florida is not going to obligate these inspections, do you have a sense in your community of engineers that there is going to be an opportunity for people to easily find engineers to complete these kinds of inspections?
Well, I think that my concern would be this, is that anytime we have something like this occur, there are going to be engineers that are going to stand up and say, I can perform these inspections for you for $500. Well, this shouldn't be a $500 inspection. If somebody's offering to provide the inspection for you for $500, you should run the other way.
Right. Right. I guess the value is going to, at some point, the cost, I guess, is going to be obviously very dependent upon the size of the property.
Yeah, there's multi different factors that go into the cost associated with it. What's the size? What's the age? What's the maintenance history? What's the record keeping? Do we have building plans? What's the construction type? I mean, these are all different factors that are going to go into it. But what I would say is that there are, and I forget the exact numbers that we looked up a couple of weeks ago, I want to say that there was somewhere in the neighborhood of 300 to 400 maybe active special inspectors in the state of Florida. And there's several 100,000 condominium buildings. I mean, I've heard upwards of 750,000 units.
Right.
So, yeah, we're going to be busy.
I understand. Sure.
But we're going to be busy doing the things that we love to do, which is looking out for the health and safety and helping these condo associations protect their property.
Got it. Well, Byron, I know I would encourage folks, if you want to pursue this or you want more information about it. Again, this is Byron Anderson of SEI. What is your website, Byron? It's
SEI Florida. That's Sam Elizabeth Indigo Florida spelled out .com.
Very good. Well, I would definitely encourage individuals to look into the work that Byron has done in the past and how he might be able to help you deal with some of these issues. We're going to continue to communicate to the public about changes that are being considered here in the state of Florida to address these issues because of, the sheer number of people that we're talking about that this affects. It is amazing. It's several 100,000, if not millions of people that live in these condo associations. And we obviously want people to be in the safest possible environment. So, Byron, I appreciate you coming in today to address these issues. And again, I would encourage folks to seek Byron out. And all you got to do is call up and say, hey, milestone inspection, please, 1. And then he'll take care of it.
Absolutely.
Thank you, Byron Anderson of SEI, for coming in today to share with us his insight into the value and purpose of milestone inspections. If you are a licensed community association manager, or say you are on a board of directors for a condominium, or you own a condominium in the state of Florida, and the issue of a milestone inspection is first and foremost on your mind, as a result of the collapse that occurred in the Surfside community in North Miami Beach, then you should continue to make yourself aware of these kinds of opportunities, especially if you find yourself in a building that is starting to express particular structural issues. Mr. Anderson of SEI was a great resource for this. Those of you out there who have issues with insurance companies, which many times these kinds of inspections can relate to, then I would invite you to go to our website at www.corlesslawgroup.com. My name is Ted Corless. Be well.